Welcome to Legalized Negligence, where we're discussing Florida Statute 768.21 subsection 8. And this is part 4 of a video series we're doing on the Senate subcommittee meeting, or the Senate committee meeting, Judiciary Committee meeting from January 22nd of this year, where they're talking about Senator Yarborough's bill, SB248. And so we're going to pick up where we left off last night. Let me get that screen up here, Travis, and then I will start it. Okay, that's as wide as I can possibly make it. That's the full width of it there. So we're going to pick up with a fellow named Robert Arrington, who's there in the public comment section, public debate section, and we're going to pick up where he starts.
Yes, sir. Legislators. My name is Robert Arrington. I'm a military veteran and a citizen of Leon County. I am thankful to be speaking here today, but I shouldn't be. What started as a routine need procedure that many of you may have soon turned into a fight for my life because the healthcare professionals failed in their most basic of duties. The very people who hold their lives in their hands when they're most vulnerable nearly cost mine. But after 3 painful, grueling years, it did lead to the amputation of my left leg above the knee. Along with losing my limb, I now look forward to a future plagued with hip, back, and neck problems. But this could easily be anybody here in this room or you. When victims of medical malpractice are killed or permanently and fundamentally changed, how can you put a limit on what it takes to put those lives back together, especially since they broke those lives, especially when the lives are as varied as a neglect that changed their lives forever? If you can trust a jury to render a verdict, then why would the trust stop there? Lastly, let us not forget we're the victims, not the insurance companies. We didn't ask for these injuries. We trusted a hospital to keep us safe, just as we trust you legislators to govern fairly with justice. And while jurors can render justice, the cap has never held anyone accountable. Thank you.
Thank you very much.
I love that last thing he says. A cap has never held anyone accountable. That's a really powerful statement, because what he's saying is you can put all the caps on this stuff you want, but it is not going to hold these doctors accountable. And of course, I like what he had to say about, if you can trust a jury's verdict, then you can trust a jury's award. If you can trust the people that make up the jury to elect you to office, then why can't you trust what we think? And it all goes back to self-governance. We know how to govern ourselves. We've just put you in that position to do what we want done.
Yeah, I like the fact that insurance companies are not the victim. He pointed that out, and that's 100% accurate.
Absolutely. Absolutely. The next fella up is, his name is Stephen Watkins, so we'll listen to what he has to say.
Mr. Arrington, Mr. Watkins, Stephen Watkins, followed by Philip Gold, followed by Jose Medines, I think, but I may have mispronounced that. And Mr. Watkins, you recognize?
Hi, my name is Stephen Watkins. I work for Flagler County Sheriff's Office. I have for 13 years. I started at corrections. I'm now a dispatcher because I'm paraplegic, had a staph infection. I was going to go one way with what I was speaking, but listening to everybody, all the reason why you're for this is because it's going to help the insurance malpractice. So it's cheap, it's better for the doctors. However, 8 years ago, I didn't need any medical supplies. Well, now I do. And those medical supplies are constantly increasing. So why does it that? Because their malpractice insurance is more important than my medical supplies increasing each year. And I get it that you want to bring doctors to this, but they also have to have accountability for themselves as well. They make a mistake, if they do something wrong, that's on them. If I had nothing to do with where I'm from, mine was a staph infection, it was a disease. So only thing I want you guys to think about is, why is one more important than the other? Thank you.
Thank you.
And I think what he's getting to there is, going back to what I said yesterday about our logo, the state against the people. Why is the insurance or the doctor's concerns more important than our concerns? Why is it that you want to give the doctors protections and you don't want to make sure that we're protected? He kind of confuses economic and non-economic damages, but he does make a very good point. that, you know, if the doctor's rates are going up, you're paying attention to that. But the fact that medical supplies are going up as well, and he'll probably be in that wheelchair his entire life, you know, and who's to know what medical supplies are going to cost him in 10 or 20 years. So
How about we cap the cost of medicine to a certain amount, just like they want to cap the future care of all these victims to a certain amount.
yeah,
I'm
sort
like, look, if the cap is good enough for us, why isn't it good enough for y'all? Y'all cannot increase your charges at all.
yeah, kind of like when you get grandfathered in when a new law is passed and you don't have to comply with it if you were within compliance of the law before the new law passed. Like, okay, cap it. This guy will never have to pay more than X number of dollars for a box of whatever it is he needs. You know, why not cap that? You know, if you're going to think about one, you got to think about the other. This next fella up is an attorney named Philip Gold. So let's hear what Mr. Gold has to say.
Stephen Gold,
Or Stephen
I
Gold.
believe, right?
No, Philip Gold.
Where am I? Oh, I'm sorry. I was reading two cards at the same time. Phil Gold, you're
Thank you.
recognized.
Thank you, Chair. I'm a medical malpractice practitioner for 17 years. I've testified before y'all last year, the year before, the year before. There's a difference between economic and non-economic damages, as Bill's sponsor makes very clear. But the way it plays out is that medical expenses that come to our clients go back into the system. They get money to have care in the future. And then when they receive that care, the money that they're receiving goes back to the medical provider or to big pharma for having pain meds. It's only the non-economic damages that compensate the victim personally, right? It's not non-economic damages. They're defined. It's disability. It's impairment. It's deformity. Those are the elements of damages that you will be voting to limit to $500,000.
Thank you, Mr.
When a
Gold.
bovie burns half
Mr.
your
Gold,
face.
Mr. Gold, I have to call the next speaker. Thank you for being here, though.
You know, he makes a very good point. You know, he recognizes the difference between economic and non-economic damages. But he makes a very good point about, you know, the cap being at $500,000. You know, how do you place a cap on the value of someone's life? And the non-economic damages are really the only way to you know, to compensate the victim of malpractice. But that really applies only to those who survive the malpractice. It doesn't really apply to those who don't survive the malpractice. But it's the only way that the system has in place to, you know, show some restitution to the victim, because the money that they're going to get in the non-economic damages are simply going to pay their bills and any future medical costs they have due to the negligence.
Yeah, one thing that I just thought of is, you know, PTSD. You know, it's like today they might be angry. A year from now, they might be suicidal over their condition.
Yeah.
You know, and might need more care and such treatment than what the cap allows, because this is unexpected.
Yeah. Yeah. And I know that there are some provisions in place for children who suffer malpractice, because you don't know what their future is going to hold and what needs they might have in the future. But you're right, you know, with some sort of trauma victim like that, and I don't know if it's fair to call it a disease process. I don't know if PTSD would actually fall under a disease. It's certainly a recognized psychiatric condition. But who knows how that's going to progress and what it's going to lead to. You're 100% correct. This next guy is Jose McGinnis, and let's listen to what Mr. McGinnis has to say.
Jose, and I apologize, Mejenes, followed by Chris Newland, followed by Steve Asencia, and please pronounce your name for me, sir.
Sure, thank you. My name is Jose McGinnis. I traveled here from Miami today on behalf of my son Bradley, who's 4 years old. Bradley was a victim of medical malpractice and suffered brain damage. He now lives as a quadriplegic with cerebral palsy, epilepsy, vision impairment. As a father, it's hard to cope with all the things that you want to do with your kid. Throwing a football, throwing a baseball. There's a lot of things that create that quality of life, that happiness. To put a cap on that is taking away his dignity, taking away his value on what he can do, on how he can be a part of this community. Bradley can't sit, he can't stand, he can't talk, he can't speak up for himself here. Okay, gets fed through a G-tube. All right, you all talk about balance here. The balance that we have at home is very different. Okay, as a parent with a kid with special needs who's going to be fully dependent for the rest of their life, putting a price on what that looks like, on what that quality of life looks like, is detrimental, not only to my son, but to everybody else in his position.
Thank you.
Thank you.
Chris,
You know, subsection 8, the reason that we've been fighting it is because our loved one died. But when you're talking about a situation where somebody survives the malpractice, but their life is altered forever because of it, Senator Yarborough's bill now brings those people under the same restrictions that subsection 8 used to have. You know, there's going to be, and what I mean by that is the caps that his bill wants to put on our ability to sue for non-economic damages did not used to affect these people who survived malpractice, but now they will. So they have a stake in this too. You know, he could have, if this bill had not been brought, this fella could have sued for more than the 500,000, but now he's going to be capped where we didn't have the ability to sue at all, but now we're going to be able to sue for up to 500,000. So what he's saying is that, you know, now you're changing our life, you know, and the lives of anybody else who survives medical malpractice.
Here's a thought I had that a result. What about the loss of freedom of people who become dependent on a conversion of a vehicle or the home in order to deal with the malpractice? Are they stuck at that home now because the cost to convert another home to take care of them? They've lost a good portion of their freedom to move about in that respect.
Yeah, and I like to use the word liberty versus freedom here.
Sure.
And the reason I do that, I'm not criticizing you. The reason I do is because we have the liberty of movement. And where I get that from is when a cop places you under arrest, he is arresting your liberty. You are no longer at liberty to move and do the things that you want. And you're correct. Somebody who is now bedbound at home for the rest of his life and is dependent on others to take him somewhere, he's lost his liberty, at least to some degree. And what is it that we said in the Declaration of I can't believe I just froze up on that Declaration of Independence? Life, liberty, and property. Well, they changed property to pursuit of happiness, but originally in Jefferson's first draft of the Declaration, it was life, liberty, and property, and he plagiarized that from Locke, and Locke plagiarized that from Sidney, but it did make it into the Declaration. But those were the important three that they talked about: our life and our liberty and our property. And you're going to be affected forever by that, man. Because that was Mr. McGinnis, and now it's Chris Newland.
Newland, followed by Steve Essentia. Chris Newland. Mr. Newland, you're recognized.
Thank you very much, Madam Chair. Thank you, Chair Yarborough, for, as you mentioned, threading the needle. This is not, in its original form, a free kill bill. There are ramifications for the doctors. There are compensations that are awarded, the actual economic damages currently. But we understand that there is a problem that this bill wants to address, but that will raise malpractice premiums by placing a reasonable cap on non-economic damages, not just the medical, the economic, the non-economic damages. We strike a balance. This is a tough job, senators. And thank you, Chair Yarborough, for recognizing that and coming up with a balanced solution. Thank you. We support the amendment.
Stephen,
Here we go again. You know, he just throws out some accusations, doesn't give any data to really support that. And, you know, it's the same old battle cry over and over. It's going to raise malpractice premiums, and which I'm going to be doing a podcast as soon as we get through this series. I'm going to be doing a podcast about why it doesn't raise it. It's all a matter of the insurance companies not setting aside enough money in their reserves during the good times to make up for the hard times. They actually call it a hard market and a soft market, and it can also be referred to as the boom and bust cycle. And I'll be laying all of that out in an upcoming podcast. Travis, did you have anything to add about this fella?
No, just that. Better off not.
Save your breath. Yeah. This next lady that speaks I think it's Megan Fowle is her name, and she's an attorney. So let's hear what she has to say.
HCA Waves and Support. Adam Bassford. Is Adam here? Associated Industries of Florida, Waves and Support. Gary Guzzo, Florida Insurance, Waves and Support. Thank you. Steve Wynn, Florida Osteopathic Medical Association, Waves and Support. Beth Young. Is Young here? Waves Against. Katie Webb, APCIA, Waves and Support. Thank you, Katie Webb. Fraser Cobb, Duval County Medical Society, Wave and Support. Megan Sowell. Is Megan here? Megan, followed by Robert Travieso, and then Tim Graves. Thank you for being here. You're recognized.
Thank you, Madam Chair. I just wanted to start off by saying thank you for being able to hear me. I'm a medical malpractice attorney from Jacksonville, Florida. When I started my legal career, I was a prosecutor. I had the privilege of representing the people of the state of Florida. We had a motto, pursue justice always. And I just want to stress the committee, this does not pursue justice. If you apply it to a criminal application, to put a cap on a homicide case at 10 years in prison is not just. And if we're not going to do that when someone's been harmed by our community in the criminal side of things, we certainly should not be doing that in the civil side. To put a price on a death of a 3-year-old girl at $500,000 is shocking. To put a price on a 49-year-long marriage where the wife died as a result of medical negligence is shocking. And to put a price on a stay-at-home mother who is there not only taking care of the home, but supporting her children, being there, being a loving wife, being a loving mom. I'm the product of a stay-at-home mom, is shocking and it's wrong. And I encourage all of you to pursue justice.
Thank you, Robert.
I like what she
I
had.
like her.
Yeah, and you know, she makes the same point. You know, she uses the examples of, you know, a criminal who's been found guilty. Where I would disagree just slightly is, yeah, there are sentencing guidelines that the courts have come up with for this kind of law or this kind of crime. You know, it runs 10 years to 15 or 20 years to 30, and there's guidelines in there that the judges all go by. And more than likely, I haven't studied that at any depth, but more than likely one judge would probably say, well, you're going to jail for the rest of your life. The other judge might say 25 years is good. So they had to kind of get some guidelines so all judges would go by the same rules. I read a book back in the summer about a judge or a judge that wrote the book who talked about that, how they had to go by certain guidelines. So there's some level of fairness when they're handing out sentences to people. But she makes a very valid point. You know, it'd be like capping a murder at 5 years or 10 years, and that's all you got to do. You know,
See, that's in the criminal realm, and this is civil. And, you know, it's the state meddling in the affairs civil domain. And we have no say. You know, it's just the legislature doing what they want until we challenge it in the Supreme Court and get it overturned.
Yeah. That's the point. As I know you saw my podcast earlier about the Department of Health. That's the point that I was trying to make is, man, that's a star chamber. Those people are locked away in private. Once they get the information from us that they think is sufficient, then we don't know what they do with it. We don't know how they present it to the prosecution unit or to the probable cause panel. We don't know if they're making the same arguments that we would make. We don't know if they understand the importance of this or that. So how are, they're not vested like we are. And so we never know. And that's why we want our day in civil court. So we can, say to our attorney, this is a point that needs to really be pressed here. This is something that the jury really needs to understand. Doesn't happen in the administrative tribunals.
I don't know if you'll remember, but one of our Zoom meetings with Mark Delegal, he had no problem with us participating in the Department of Health hearings.
Mhm.
He thought we should be there. So that just kind of shows that it's the department's policy. The Department of Health doesn't want the people there.
Yeah, and that's why I call it a star chamber. They think that they're above everybody else and that they've been given this authority to do something, and that means that we no longer have authority as the people. And in civil courts, we do. That's what they're there for, to give us the opportunity to argue our case when we feel like our rights have been violated. So, all right, the next one coming up here, that was Megan. The next one is Robert Travieso, who is a malpractice attorney.
Travieso, followed by Tim Graves or Groves. You're recognized.
Good afternoon. My name is Robert Travieso. I'm a lawyer. I represent the victims of medical malpractice in Ponte Vedra, Florida, and throughout the state. I'd like to draw the committee's attention to who exactly will be harmed by this amendment. We are not, as Senator Book astutely pointed out, we are not dealing with frivolous lawsuits in this instance. Each and every medical malpractice claim that is filed has gone through a pre-suit validation process. It requires an expert healthcare provider's sworn statement that there are grounds to pursue a claim for malpractice. That case then has to go to trial, where a jury of the plaintiff's peers then determines that the doctor committed malpractice. They don't even reach the decision or the question of whether what the damages are going to be until they've decided that malpractice was committed. And then is when they make their decision of what the facts and circumstances of that case justify in terms of damage. Thank you.
He raises some very good points, the stuff that you and I have been saying now for a year. The whole pre-suit requirement thing, that gets rid of anybody who would bring a frivolous claim. And I know there are some out there, and it's not because the people are money hungry. It's because they simply just don't understand what happened. And it's because the moment some adverse incident takes place, the doctor in the hospital begins to circle the wagons. They withhold information from everybody. That naturally makes us suspicious. And so the only way that we can penetrate that veil of secrecy is to hire an attorney to be able to get in there and do anything. Well, if it was easy to get an attorney, then he would have to follow the pre-suit requirements, and he would get a medical expert, and that medical expert's opinion would go up against the doctor's medical expert, and we would be able to hash it out. And once, as Tom Baker's research has shown, once people understand what exactly happened, 24 out of 25 allegations of medical malpractice go away. That means one makes it through because somebody finally took the time to sit down with the patient or with the patient's family and explain to them exactly what happened. And they go, okay, that makes sense. I understand.
Yeah. So a point that he made was that the expert certifies a finding, And very early this morning, I sent a letter to Senator Yarborough calling out the fact that that very thing happens, and why does DOH not take an interest in all settlement cases? Because there's no reason to go to settlement unless the pre-suit investigation has found a potential error. You know, why even talk to the other side? So the fact that they reached a settlement shows that there's something there. Yes, it could be expedient or financially important, but again, something brought you there to talk to them. So Department of Health, if they're really looking to find issues with medical care, the practitioners and such, they should be looking at every settlement and ruling that either something was there or something wasn't that can't be explained away. That would be a good way to clean up a lot of the rules.
Yeah, and what the defense counsel and the defendant know is that if they can wear down the plaintiff, the victim's family, if they can wear them down emotionally, then at some point they will accept a much lower settlement than what they would normally want to go after. Because at some point they go, I just can't take this anymore. I just want it to be over with. You know, I'll take that low settlement because I've got to get on with my life. And there are few people who have the drive to pursue this to the lengths that you have, that I have, that Sabrina has, and some other people. I mean, Sabrina's already got her finding from the Department of Health, and she's still out there fighting. You know, that says so much about her. I mean, that girl is just dogged, man. She is not going to let this go until something gets changed. But most people, they just sort of, they run out of steam, man. And that's what defense and defense counsel relies on. They'll run out of steam, accept a lower settlement, and then everything goes away. And that strike does not go against the doctor with the state once the family accepts the settlement.
Right. The only thing that will get the strike to have any effect is if there is a determination. And in most settlements, there's no determination. So it means nothing.
Yeah, exactly. The next fella up is somebody named Tim Groves, and he is a defense attorney. So we'll see what he's got to say.
Tim Grover.
Grover.
Tim, you'll tell me what your last name is. I apologize. Landon Stinson, followed by Todd Michaels. You recognize, sir?
Good afternoon, Tim Groves. I worked as a defense attorney for 6 years, the first 6 years of my career before switching over to representing victims in last October. As part of that process, we worked tirelessly with the adjusters to minimize the value of these claims. An unintended consequence of these caps would only overburden our judicial system more so than it already is. In the role as the defense, we would use the caps under the voluntary arbitration proceeding at the end of pre-suit, which caps the human damages at $250,000. That was not the end point. That would be the starting point for negotiations, with our position being that's the worst we would ever have to pay. So why would we pay that to start with?
I'm going to stop that there because that is an extremely important point. He's telling you that when he acted as the counsel for the defendant, that they're going to look at that cap and go, that's as far as they could go. Why are we going to open with that? We're going to start off with something much lower and then try to wear them down and then literally wait till the day that the trial is supposed to happen and see if they'll accept it.
That's a good
$500,000
point.
cap would likewise embolden insurance adjusters and defense attorneys across the state to say, why would we pay $500,000 to start? We would require you to go to trial to get that amount. So it would increase the burden on trial judges and juries across the state, as it would increase the amount of medical malpractice trials that go to trial. Thank you so much for your time. I appreciate it.
Thank you, Mr. Griff.
Yeah, I love the way he said that. You know, if you want the full amount of the cap, then we're going to make you earn that. You know, we're prepared to go to court. Are you? You know, and the family members sitting back there, it's already been, you know, several months at least. And they know what the family's going through. They know what kind of toll the whole thing is taken on the family, and the defense counsel is willing to put them through even more to get them to drop it.
I wonder what the effects are on the quality of the push behind the case on both sides, really, because there's a fixed amount known. You know, it's like, will the plaintiff's side push to whatever expense is required for just 500,000, regardless of the egregiousness of the case, or will the defense, you know, put forth a better defense, knowing that that's all they got to go to is 500,000.
Yeah, and a lot of times, you know, and not just, I'll say this about, and it's not just medical malpractice cases, but for any type of case, the either the state or the defense will look at it and go, well, this is how much it's going to cost me to put on this case, so I'm going to offer that and see if the people will take. In fact, they'll say, this is what it would cost you to defend this case. Let me just go ahead and give that to you now and we'll be done. And so they're going to say, we'll give them something even lower than that, you know, because we know they can't go any higher.
Well, see, here's the bad part about being pro se, is I can't collect my own time and effort because I'm bringing the case myself, because I can't get an attorney.
Yeah.
So I don't even have the benefit of that.
Yeah, exactly. And the state has forced you to be pro se. You know, they
Correct.
put you in a position where attorneys won't take your case. So if you're going to seek justice for your mom, you're going to have to do it on your own with no compensation for it. Yeah.
Correct.
There's Landon Stinson, followed by Todd Michaels, and then Waylon Thompson.
Good afternoon. My name is Landon Stinson. I'm a Christian, a father, and a husband from the great city of Gainesville, Florida. You all have a very difficult, stressful job, and I appreciate everything that you do. I'm going to share my point of view with a story. Imagine that you're on vacation in England and you're the victim of a horrible medical malpractice event. Do you have the right to a trial by jury? You do not. And that's because the American civil jury trial is one of the most American things that we have, is that when you're hurt by a doctor, 6 people from your county get to decide how much that's worth. And this amendment would put this legislature as the 7th juror on every medical malpractice case in Florida. I believe that's wrong. I appreciate your time. Thank you.
I love that point. You know, I really love that point that he makes.
That's insightful.
It is, you know, it's things. That's why it's important to go through these and listen to all these different perspectives and different ideas, different viewpoints, because, you know, the more people you have to talk about it, the more ideas you're going to see that maybe you didn't come up with. And, you know, with every one of these people, I'm learning something different about it. And just to think about, yeah, and in England, you don't have a right to a trial, you know, but in America, it was such an important thing for the people to be able to settle their differences in court that they wrote it down in a constitution. It was that important to them that they wrote it down so we would never forget it. You know, all right, it looks like we've got one more guy who's going to speak, and then we'll bring this to a close. This fellow's name is Waylon Thompson.
Thank you for being here. Todd Michaels. Waves in opposition. Thank you, Mr. Michaels. Waylon Thompson. Mr. Thompson here. Good afternoon. You're recognized.
Thank you, Mr. Thank you, committee members. I'm Waylon Thompson from Panama City. As we've heard, the Florida Supreme Court declared these caps unconstitutional on 2 different bases. One is it treated people unequally, unfairly. Number 2, the numbers were arbitrary. So why are we here today in 2024 talking about it again? Well, the purported vehicle is to right an injustice that everybody here says acknowledges exists, right? So how are we doing that? Then we're trying to do that by, again, limiting the amount and treating people unfairly. Why do I say that? Well, if you're a Medicaid recipient, guess what? Your number is limited to 300,000. We haven't heard about that today. All others is 500,000. So a half justice is no justice at all. So are we going to tell the poor people of our state that you're not worth what other people are worth? This is a bad amendment. We need to, excuse me, have the amendment stricken, as Senator Book had suggested, and have a vote straight up on eliminating the exemption. Thank you.
He makes a great point, man. You know, this whole thing is about the legislature created a class of citizens and then it punished it. And now those same citizens, and now here we are 34 years later, and the legislature still continues to punish people by placing a cap on them. They're not treating them equally like everybody else. You know, there was part of Senate, I can't remember if it was in Senator Yarborough's original bill. No, I think it was in his amendment, where emergency room physicians are going to have a cap of $150,000, I believe it is, half of what the Medicare recipients get. And I had to think about that for a while. Why would you do that? And what makes sense to me, or I'm not saying that I agree with it, but my understanding of why he would have put that language in there, you get an emergency come in, the patient is not even stabilized yet. You're trying to stabilize the patient. So the state is giving them more room, a wider berth to make mistakes. So if the doctor does make a mistake, then he's not going to be penalized as heavily as if the patient had been stabilized, moved to a floor or to a special unit like the ICU, where they have a better handle on what's going on. And I couldn't help but think that that language in the amendment wasn't written specifically for Taylor Jenkins, you know, because she would have fit that scenario just perfectly. I think if I remember right, it was like for 11 hours, the doctors missed a torn artery in her pelvis. And this would have this part of his amendment would put a cap on them of $150,000. You know, so that's why I said, and when we first did our first podcast in the series, is that it's like they listened to us talk and started writing the legislation around every scenario that we gave to them. You know, I'm sure that if you had been able to get Senator Yarborough to understand the issue of the missing images from your mom's chart, he would have probably put something in there about, you know, well, if some images go missing from a patient's chart, then we're going to put a cap on those people with $50,000. You know, it's almost like they tailored this amendment to cover every problem that we presented to them. You know, I hope I'm wrong about that, but it sure does appear that way. You know, I'm not making an accusation. I'm just making an observation.
Yeah.
Travis, do you have anything else you'd like to say about this?
Well, if we can have caps placed on us, I would be interested to see if we can't have them placed on them. You know, if it's good for the goose, it's good for the gander. Can we limit them to all forms of economic gain to a cap while they hold an office, or even as a result of them holding office after they leave?
Yeah,
you know, because we don't know. We don't know what benefits they had established while they were in office to benefit them after they left office. So let's throw caps at them. Their lifetime earnings is capped at 500,000.
You know, I'll tell you something that's been troubling me, and I've been trying to think it through, and I haven't come up with an answer. They're talking about a per complainant cap. Okay, so how do they determine who gets to be a complainant? Do you go by the standard that's used where, you know, generally it is the spouse. If there is no spouse, then it's a child who would be considered the next of kin. If there is no child, then it would revert to the parent. You know, there is a hierarchy there of who is determined to be the next of kin. So I haven't seen anything in his bill or his amendment that determines who gets to be a complainant.
That might be part of the original statute of wrongful death, where it talks about the children and the parents. That might be the total definition of who can bring a claim.
Mm-hmm.
When I was walking the halls at the Capitol, I spoke to an aide of, on the first video we did, the lady, the representative in the red jacket, short hair, who was for the bill.
Senator Harrell.
Harold, yes. Her aide brought that very thing up, is how do you determine who can be a claimant? And the best I can think of is what I think it's like subsection 2, 3, 4, and 5. I think it's within those of the wrongful death state, the children or the parents. Those are the only ones. I'm not sure. I really don't know.
My experience in dealing with that was when I worked with the organ donor program doing organ transplants, and you know, a patient came into the hospital and you determined that there was a potential for organ donation. You had to determine who was the next of kin. And if the person was unmarried, the next of kin would have been the parents. If the person was married, the next of kin would have been the spouse. If the person was married but the spouse had died, the next of kin would be the children. And there was a hierarchy to, you know, who had the authority to give consent for the patient to be a donor. And I just haven't seen that spelled out. You know, they're acting like all of these complainants are going to be able to recover up to the limit of the cap, but how do they determine who that is? And maybe I just need to go back and read that section that you're talking about, but you would think they would specify that in this bill, since they went from aggregate caps to per claimant caps. You would think they would want to write it in there.
Well, that would be the next legislative session to constrain that. I'm serious.
Yeah.
Boil the frog.
Yeah. You're right. You know, and this person died and there were 5 people that sued. That was the equivalent of $2.5 million. We got to do something about that. So now we're going to make it where there can't be more than 2. And then the next legislative session, no more than 1. And by then they might have achieved their goal of getting it to where we don't have juries anymore in America.
And the medical care would still be bad.
Yeah.
Nothing resolved.
Yeah. So, well, if you don't have anything else to add, I'll get this one finished out and uploaded, and then I'm at the end of my notes, so I've got to go back and watch the rest of the video and make some notes on that. Maybe we'll have time tomorrow to wrap it all up. So far, I think it's been a pretty good series. I hope you agree.
I do. I have some constitutional questions. I'll get with you afterwards.
Okay.
Maybe that'll be another video.
Thank you for joining us. And you know, all the stuff that everybody says, we're not attorneys. We're considering playing them on TV at some point, but right now we're not. Like and subscribe and hit the notifications. Ask your friends to join. I've noticed that with each part of this series that we've done, the views have dropped significantly from each one. And I don't know what that means. Is it because it's the weekend? Is it because the weather's bad? Is it because people are losing interest? I don't know what it is, but you would think that this would be when people would be really wanting to understand what's going on. But I'm seeing every day there with each consecutive video, the viewing has dropped with each one.
I'd like to think that they're busy writing letters to Yarborough, Senator Yarborough, and giving him their ideas.
Or making phone calls. Inside joke. All right, Travis, hang on and we'll chat for a minute after I end this. Thank you, everybody, for joining us. Let us know if you like this and we'll keep it up. Bye.